Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London. This morning I'm looking at a really fascinating book. It's actually an historic book, really, but it's about law and it's about arbitration and ADR. Now, alternative dispute resolution we probably think is relatively new in some respects. It isn't. It's very old, actually. This book is a book about the ADR system during Queen Elizabeth I's reign. It's called The Golden Age of Arbitration, dispute resolution under Elizabeth I, and it's been written by Derek ROEBUCK. It's published by the Arbitration Press. That's the front, the side and the back. The Arbitration Press is HOLO books in Oxford. You can see the information there. This is a hardback. There's a nice cover. There's a picture of Derek in the front, dust cover sleeve with some information about him, and there's information about other books in the series. They've produced a number of very interesting books, have HOLO Press. Now, there's a very detailed index which you can see at the back. It's a lovely little book, this one, very easy to read. There's a very detailed bibliography. This is a very scholastic work. There's been a lot of effort put into it. There's also a very useful glossary of terms because, as you recall, Henry VIII started English as the formal language, but there's still a lot of very large number of words which may have some confusion, so it's well worth looking at the glossary if you have any problems. Now, let me just say that the text is standard text to just read through, and there are detailed footnotes which refer to particular points which are made all the way through. And at the front of the book you've got other books by Derek listed there. You've got the nice front cover there. It's a nice dedication to his father. I like to mention the dedications. There's a lot of work that goes into these books. Then you've got the structure of the book itself, an introduction, public arbitration, procedure, the people involved, parties, women and so forth, the subject matter that was covered, and finally the law in the courts and conclusions. I think anybody who's involved in the history of English law would again find this very interesting. There's a preface there which sets out what the purpose of the book is, and he does say, this book has been a joy to write. I would say it's actually a joy to read as well. It's a very nice book. There we go. And then you're straight into the introduction there, and then you've got the background and where we go. As I say, I found it fascinating, and I think with the interest in the Tudor period of history at the moment, I'm recording this in the spring of 2015, this book is something I think which would have a much wider interest value for people, not just for lawyers. And obviously alternative dispute resolution is mediation, the whole concept of how we do our business, which is very much at the forefront of government policy as we enter this election period. It's all about money at the end of the day and trying to resolve some of these disputes. I would also say that arbitration and ADR can in many ways be very helpful because it does avoid the brutality, frankly, of what is cross-examination and the trial. So therefore it's something that we do try to get away from if we can, to basically help the parties to resolve their differences. Now, my wife Elizabeth and I had a good look at this book and had a nice chat about it, thought it was really excellent. We've come up with this title, Calling All Arbitrators, Your Profession is Nothing New, which is what I've said before, in fact, and that is that this is not something that's just come about. We've had it for a long time. And if you think about it, it makes sense, even going back to Solomon, if you like. It does make sense that you try to have some concept of trying to mediate the warring parties. This is what we say. Dispute resolution under Elizabeth I is to most readers, including lawyers, a rather startling subtitle for a book about arbitration. But here it is, a meticulously researched and actually un-put-downable discourse on how disputes, arguments and fights between warring parties were resolved in the 16th century during the reign of Elizabeth I. Now, fans of Wolf Hall and other works of fiction about the Tudor period will quite possibly be shaken to the core by the facts as revealed in this quite absorbing book, not to mention the variety of ways in which the decisions were made and justice meted out. What is immediately impressive about the book is the style and vigour with which author Derek Roebuck writes, which makes the book a rattling good read, and also, more importantly, the wealth of archival material and documentation from the Elizabethan period, which he has painstakingly ferreted out and quoted extensively. It's fortunate for modern historians that those in government at the time of the First Elizabeth were so punctilious about writing almost everything down and keeping records. There's nothing like the study of original source material for gaining a more accurate understanding of the realities of an historical period. The archives of documents for these years relating to arbitration are voluminous, says the author, adding that because of the richness of its archives, Elizabeth I's government arbitration scheme dominates this book. He also points out, however, that the background to dispute resolution throughout her reign was private arbitration arranged by the parties and the chosen arbitrators with no government intervention. Which is interesting because whilst we don't have government intervention in that sense today, because the judiciary are separate under the separation of powers, obviously the government does have an interest because of legal aid and because of the overall funding of the court system. That's where the interesting business comes in. Anyway, let's go on. The book is divided, as you've seen, into 7 parts. All, you could argue, uniformly interesting, but particularly noteworthy is part 2. On public arbitration, which contains a chapter on the Privy Council. The council was the Queen's government, says Roebuck, travelling with her whenever she went, usually around London. It also met in Greenwich, Richmond and Windsor, and as far afield as Stansted, Hertford Castle and St Albans. Far, in those days, meant literally that, when the average journey on horseback covered about 15 miles in a day. And of course, remember, the Queen took a lot of people with her when she went. The Privy Council is an important organisation. It's still very important today, and at that time it comprised 19 of the Queen, that's Queen Elizabeth I's, closest associates, including some familiar names: Sir William Cecil, Robert Earl of Leicester, Sir Francis Walsingham, and the then Chancellor of the Exchequer, Sir Walter Mildmay. Apparently no claim was too large or too small for its consideration. The claims heard, for instance, in 1585 included a dispute between Town and Gown in Oxford and other various arguments over property and money. The council even sat on Christmas Day. In 1596 there was a plea to the Lord Mayor, in time of famine, to moderate his diet so he could afford more poor relief. Interesting precedent being set there. But it was in 1588 that the council had to deal with imminent invasion by the Spanish Armada. On the 23rd of July, it issued letters to several counties saying that whereas the Spanish fleet has of late again been discovered on the seas, they are required to put the forces of the counties in readiness, namely levies, bullets, gunpowder, lances and beer. Only a few days later, the council then found itself arbitrating in a family dispute between one Cecily Inglebert and her son. So you see the balance between the type of hearings. So many claims, so little time. One wonders how Elizabeth's government coped, for the most part successfully, especially in the midst of crisis. Elizabeth, says the author, should be given credit for what seems to modernise to be a precocious government scheme for the resolution of disputes. We've got it today. I wonder how precocious it is now. An interesting point. Covering every conceivable aspect of dispute resolution, this is a lively and erudite exploration of a fascinating subject in an equally fascinating and well-documented period in English history. The general public, we think, will love it, and lawyers in particular will note the links between arbitration, which then encompassed mediation, and the evolution of the English civil justice system. Arbitrators themselves will realise that arbitration as a means of resolving disputes is certainly nothing new, and the publication date is cited at 2015 As I say, I've been really impressed with this book. Let's have a look at it again. Nice pictures there at the front. And then, as I say, there's Derek in the inside front cover. Some of the books they produced, and then at the back, quite a lot of information. They have a large range of books, and it's a new publisher to me, but I'm very impressed with the quality. It's very high. There's the index again. And if we just open it up in the middle, let's find something. International Trade and Foreign Relations. Again, that's right in the middle of the book. You see you've got footnotes as well. There's a lot of, as I say, meticulous research and a lot of quotes. So he's done his homework, let's put it that way. But he's made it a very interesting read. Anyway, can I thank Derek and all the people involved in this book. There's been a lot of work obviously put into it, and I think it's a great benefit to everyone. And I think anyone involved now in ADR today should read it, because they will find probably interesting parallels between what happened then and the way we do our business today. Because frankly, when you get down to it, an awful lot of the problems we have are not something that's new. We've had them before, and we're going to have them again. Thank you to all concerned anyway. It's a lovely book to treasure. Bye-bye.